dismiss on withdrawal, interim order to any shall stand vacated. At the request of Mr.
I think it's for the respondent. The respondent will not be allowed to get.
You are here for the respondent.
Yes, for respondent about 2 million.
Yes.
A date may be fixed next week.
At the request of Mr. N.K. Das, appearing N.K. Das, appearing on behalf of the respondent. Number 2. And with the consent of the learned counsel for the petitioner, matter stands adjourned. This on 22nd June.
Yes, he said also, I'd like to mention item number 20 of today's hearing. English counsel Mr. P.P. according to the letter for the honorable court due to some medical emergency hosted.
At the request of MS
I
A. Hussain.
I
Hussain. Appearing for the petitioner, matter stands adjourned for 1 week.
after 2 weeks.
After 2 weeks. CD receipt?
CD receipt.
CD receipt be retained till the next week.
Details will be continued.
Till the next week fix. This on 27th June. Interim bail, if any, will continue.
I'd like to mention item 36 of deliveries. That will be attended for 1 week.
You are mentioning on whose behalf? Your name, please. Your name, please.
Assignment.
Mrs. Ahmed, by the council. Appears for the petitioner and please for adjournment for a week. That matter be adjourned for a week. List after 1 week.
Daily list for motion item 1.
Is a 439 application, my lord, registered on 17th of April, my lord. One of the FIR is a page here, but I apologize, my lord, while printing, some words got stuck together. May I be permitted to place the proper type copy, my lord?
No, it doesn't matter. You can do it in page number.
Page 12, my lord.
Page 12.
Some words were stuck together while printing.
Yes.
General against you, Avinash Bora, for administering an alcoholic substance to Santanu Doctor. With due respect, this is to inform you that a birthday party of my son, Shriman Santanu Doctor, was organized today, and taking advantage of my being received for the same, Sri Avinash Bora, resident of Pokamura Sarili, had some intoxicating substance causing unconsciousness. After seeing the said incident, I immediately inquired about the same from him, but he failed to give a proper reply and started making meaningless statements before us. I and my husband, Sri Rubodati Doctor, had called other members of the house and took him to Jorhat Medical College Hospital, and now he's undergoing treatment there. Therefore, I request him. And he was arrested on 17th of April, madam.
Let us start to see.
My
That CD along with medical report. Report. Guarded counsels for the petitioner and guarded executive state. Tell us when you can get this. Jorhat. 20.
my
This one 20.
deviate.
Item 2.
Section 25-23, under section 120B, 420, 328 and 392, madam. Actually, in this case, madam, I am not FIR in the case, madam. Lady, madam, and another it is the father in the madam. Both of them were picked up because, madam, inside of Habibur Rahman, madam. This happened to be ladies.
Let us CD. CD. Let CD be called for. List on 22nd. Let it counsel for the petitioner and 12 for the state.
I have 10 and 16, madam. Already
16.
from Gopur, madam.
Let it be on 19th.
August.
Item 3.
Is 9.
arrested on 29, 23.
Where is the earlier order?
30.
Is it before this bench?
Yes, that's right. Page number 30. 30.
30.
Yes.
Hold on. Let CD be called for,
No,
along with
164.
164 statement.
There's a specific allegation in the order.
What is the new ground?
New one is is only child of my his mother, mother alone mother. That is annual mother. Election number.
All right, list on. This is coming from Kamru. List on 15 June.
supplementary list, motion item 40,
It is the for 13 in the very case, let's say. And we live in the 306 and 34, I think. FIR is on page 6, let's say.
Page 9.
Page 8, 9, let's say.
Let CD be called for.
Let's say CD is available in on corrected method, the base application 1906 let's say. And that method, let's say. takes on-
306. CD along with TM.
Let's say, here, let's say, the method is, case is registered on T06, let's say. And, FIR itself reveals that.
No, you are mentioning about a similar matter. Fixed, when is it fixed?
Six on 19/6/2020.
Let it be on 19. Arising out of the same FIR. Is the other matter arising out of the same FIR? It is submitted by learned counsel for the petitioner, Mr. M.K. Neu, that a similar a bail petition arising out of the same FIR is fixed on 19/6. And CD has been called for.
It is available, only PM report was not available, and PM report was not.
Accordingly, let this AB petition be listed along with, what is the other number? Sorry, BA petition,
1903 of 23.
BA 1903 of 23. And on the next date fix, the CD along with postmortem report be produced. List accordingly.
41,
This is the for 39 pages. After I just page 12. This is registered under section 457 PHP IT. Petitioner was arrested on 5/2/2020. Its hearing is already over.
60-day offense.
Yes,
What are the sections?
457 PHP.
Yes, Mr.
My lord, I will have to take instruction letter to the charge sheet submitted.
Tomorrow,
Well,
you can take
my
it
lord,
tomorrow
telephone again, I will take it up.
or on Monday.
My lord.
Tomorrow.
Monday, my lord.
Monday.
Monday.
Mr. B. Sharma, learned APP submits that we'd like to obtain instructions as to whether charge sheet is in file in the matter in the meantime. Accordingly, we'll let the matter be listed on Monday, which is
Can
well,
anything use the Monday?
13/6. Also, Mr. Bora, learned counsel for the petitioner submits that the petitioner has been in custody for 60 days.
Already 60 days.
60 days in all.
That's only for 124 days. 124 days. No, not yet, sir. We have a record.
5/2/23.
5/2/23. 124 days.
According to- Let the matter be listed again on 12.
Right.
We'll consider 13. 13.
Right.
For motion item number 4,
Can I please your lordship? This actually, taken up, listen.
We'll have it next week. With the request of Learned Council to the petitioner. Matter adjourned, this next week.
5,
Yes, Mr. Bo.
For prayer for washing and starting matter. But what happened, I take the lordship to the affair. It is because of misunderstanding between the family matter, the affair was always talking matter.
Hmm.
With reference to the practice above, I have the honor to state that the information that my cousin sister was forcibly taken inside the operating providing of the OED, the Ryan mobile number different side, along with her maid friend, last night around 7:30 p.m. and to 8 p.m. and was taken from my own residence, Haflong. Is released under the Mahata mistake. Again today, I received a phone call from around 1:19 p.m. that a ransom would be picked up. And both the part of the arrested is taken to custody matters. During the bail matter, I take the request 20 matter. The informant appeared and submitted a affidavit matter that because of the misunderstanding, her cousin was for meeting her cousin,
Page number?
page number 1, page 201.
Hmm.
And because of this, he has admitted that the bail will be granted now. But then according to page 21, Honorable High Court has granted bail them. Now the charge sheet has been filed against them under 364A. But my own case, this limited bad is noted by the done by the issue to that's number 2, but then she can't appear to the court.
But Mr. S.A. Viswas, Learned Counsel for the petitioner, its criminal petition is filed by the petitioner praying for washing of the criminal proceedings, the Haflong. Relating to Haflong case, case number 22 of 2023. Which is pending before the court of CJL, Timaha South. And charge sheet in the matter by the charge sheet number 17 of 2023 having been filed. And for quashing of the same charge sheet. And all further proceedings thereto. Learned Counsel for the petitioner submits that an FIR dated 2/3/23 was lodged by the informant one, so and so, alleging that his or her cousin was forcibly kidnapped by the petitioner on 1/3/2023 and the demand of ransom money of 50,000 was made. Also, he submitted that the petitioner, she's on bail now,
Yes, yes. Honorable High Court.
was arrested and subsequently released on bail by the orders of this court. Dated
Matter dated
22
22/3/23.
03/2023, fasted BA 1093 of 2023.
Yes.
Also, it is submitted by the Learned Counsel for the petitioner that an affidavit sworn by the informant on 13th day of March
23.
2023 before the notary public Haflong, wherein it is stated that the FIR was filed because of some misunderstanding, as her cousin did not return home and she was unable to ascertain her whereabouts. Full stop. it was stated in the affidavit that she had no objection to the grant of bail to the accused petitioners. Also, then the counsel for the petitioner submits that under such circumstances, there is no cause to proceed in the matter, and the police ought not to have proceeded to file the charge sheet in the matter against the petitioners also. Whereas Mr. B.B. Gogoi, learned APP submits that the allegations are serious in the FIR, and therefore whether the matter can be compromised is an issue that will require some hearing in the matter. Accordingly, let notice be issued to the respondents. Mr. P.V. Gogoi represents the state of Assam, and therefore no fresh notices are issued. However, extra copies be furnished within a period of 1 week from today. Steps on respondent 2 by registered post ID. Are you willing to take Dusty also? Dusty is also permitted. What is the state of the case now? At Kiri.
Not more date has been given.
All right, then we'll list it after 3 weeks. List after 3 weeks.
Item 6,
This is question quickly. Lordship can say FIR as well. We have challenged the FIR under the order of the land extension government. And we see as well. Here, the informant is my daughter-in-law. She filed a case against my son Muzammil Ali. And there is no whisper against me at all.
Your son is the husband.
Yes.
Hmm?
Muzammil Ali is my son and husband of the informant. Now, she filed a case under section 498 and 307 IPC against the husband. That is the FIR case 12. If your lordship kindly go through the contents of the FIR, there is no whisper at all against me. Then, my lord, police investigated the matter and submitted charge sheet, that is page 17. In charge sheet, there is not my name. In 161, police did not find any materials against me because nothing was found against me by my daughter-in-law. All of a sudden, she appeared before the learned trial court, that is before the instance in this Nalbari. And she said that my mother-in-law, who is the present petitioner here, has set fire on my sari. On my sari, she got fire. So that was the allegation for the first time. He brought against me before the court and the evidence is. And the learned session just on the basis of our that statement passed the order, that is page 26. This order was passed on the basis of 419 of CRPC. Now that lordship, that power is there with the magistrate, then in subsequent position. The court is satisfied on the statements of the victim or any other appropriate details. They may issue summons. But thing is here, when my daughter-in-law was in my house and she filed the case against her husband only, so there was no reason as to why she would not say about my name in the affair, nor before the police under section 161 CFC. For the first time, this is after court. She came in court and said by him. So absolutely, whether this is after court better, and I'm an old woman.
No 164 statement.
164 statement that we do not have at present. But telling this may not in charge sheet nor in FIR my name is there. So that is totally after court matter. So by utilizing section 419 of CRPC, an innocent person cannot be brought to book to fill up the to harass the person for humiliation for no legal reasons. So my submission is this: actually kindly confirm the records and till then.
What is the judgment here?
You know,
What is the judgment?
The judgment that is we prepared this revision before the learned session judge had done very against the order of assistant session judge.
Which order?
Against the order that is case 26.
Page 26.
Yeah, that is the order of assistant session.
Hmm.
Whereby I was summoned under section 419 and therefore charge was framed against me.
Hmm. Now, what happened to the revision?
The petition which we filed before the learned session judge,
Challenging this order.
he challenging this, that was rejected.
Hmm.
But thing is this, the learned session judge did not interpret the law in its proper perspective. Because neither in FIR nor in charge sheet, my name is there on, she was at my house. As the daughter-in-law and wife of my son. So at the first instance, she was silent. Before the police, she was silent. All of a sudden, she discovered some new thing. So there should not be giving a blanket license to a wife or to a woman to harass and humiliate me before others. So I will submit on law points on this figure. For the timing, my humble submission is this, Lordship may kindly accept this petition and let notice go and let her come on what circumstances she indicated me after a long period.
Yes, Mr. Goel.
Yes, not saying that pending charges might not the discretion of the court below mine. If there is prima facie case, then my lord court will take charge. That is the law. Here, my lord, in a revision session just rejected their my lord. Against the order of the session judge now. My coming to High Court.
What is this 482?
Okay. My lord, I am submitting what my learned friend is saying. The discretion, again, the question of law is that discretion cannot be exercised in an arbitrary manner. It should be exercised in a as per known sources of law. What are the known sources of law? That is the FIR, that is the charge sheet. So all these things I will argue, and I will also do citation. So far regarding second division, this is not second division. This is criminal petition for quasi. And
What is your prayer here?
there, worship that way, worship is page 9. The London session judge is order dated 25 May 22 and also the order of London session, yes. And with the first division.
Heard Mr. Vin Mahmood, Legend Council for the Prisoner. Mr. D.D. Gogoi, London Deputy for the State. This criminal petition is filed by the petitioner. Praying for washing of the order dated 25/08/2022 passed by Assistant Session Judge Mambari in Sessions Case number 23 of 2020 and judgment dated 28/04/2023 passed by Session Judge, Court of Session Judge Mambari in criminal revision case number 14 of 2022. Whereby the order dated 25/08/2022 passed by Court of Assistant Session Judge Mambari in Sessions Case number 23 of 2020 has been upheld. The learned counsel for the petitioner submits that an FIR was lodged by the respondent number 2 as the informant, making certain allegations against the accused person who was her husband and the son of the present petitioner. Also, it is submitted that the informant is a daughter-in-law of the present petitioner. On the basis of the FIR which was lodged, the same was registered as Mukalmua PS case number 136 of 2018 under section 498 capital A/307 IPC. Also, pursuant to investigation, charge sheet was filed and the accused mentioned in the FIR, namely the son of the petitioner, has been shown as the person sent for trial in the charge sheet. the name of the present petitioner was not mentioned in the charge sheet as an accused. No allegation was made against her. Subsequently, the matter was committed to Assistant Session Judge, and the same was registered as the Sessions case number 23.
Yes.
23 of 20. Also, during the course of the trial, the petitioner deposed before the trial court, and in a deposition on 25th of May 2022, she made certain allegations against present petitioner that she had tortured her and had tried to kill her by putting her clothes on fire. Also, on such statements, the trial court, the Court of Assistant Session Judge, Nalbari, by order dated 25/08/2022, framed charges against the present petitioner. Summons were issued prior to that.
Yes, after writing her statement.
Summons were issued and charges were framed against. A formal charge was framed against the petition under section 307/34 IPC. Also, they agreed the revision petition, being criminal revision case number 14 of 2022, was preferred by the petitioner before the Court of Sessions, Nalbari. Also, the Court of Sessions, Nalbari, by the judgment delivered on 28/04/2023, dismissed the revision petition and declined to interfere with the order dated so and so, whereby the petitioner order dated so and so, by which formal charge was framed against the petitioner, agreed the present criminal petition is filed. Learned counsel for the petitioner submits that this statement made by the petitioner in a deposition before the trial court was an afterthought, and during the entire investigation, no allegations, no statements have been made against her. Consequently, the trial court erred in law and on facts in proceeding to frame formal charge against the petition. Whereas Mr. B.D. Goel and the deputy appearing for the state submits that the court prescribes the powers for a trial judge to frame charge on materials available before the competent court. As such, the framing of a formal charge against the petitioner by itself is not contrary to the provisions in the code. Also, accordingly, let notice be issued. Returnable for which, since Mr. Roy appears in respect of the respondent number 1, fresh notices are made. However, extra copies of the petition be furnished within 1 week from today. Let steps on the respondent number 2 be taken within 1 week by registered post ID. Thus, is also permitted. When is the next date?
I will. Last part of this month, I think, exact date I have to.
Let notices be made returnable after 2 weeks. This matter again on 28th of June. on which date prayer for interim will be considered. You get the date, we see.
I will give it 2 p.m. I will give this to Mr. Becker.
No, not like that. You get a proper date.
It doesn't.
Item 7,
You give us a date, we'll-
No, it will be.
yes.
Please, Your Worship. Hello, I know. Under 6. Who is are tender from engineering deal by the court of the order is 19. There is matrimonial dispute between the deceased and his wife. How will you be integrated? For no reason.
Yes. Who are the petitioners?
Who petitioners are there?
How are they related?
How are they connected here?
Their name is in the society.
Where is the, do you have a copy of the suicide note?
Located at page 16.
16.
Particular 17. And the visitor was telling a story of 20 years back, which was recorded in his mobile. In fact, 20 years back, there is no mobile phone in his society.
So who is Riazu? Riazu,
Riazul is enlarged on engineering bill by the honorable court.
why are you apprehending? Where are your names?
Yes, my name is Dialog. Shah Kamal,
Sagamam.
yes, sir. Shah Kamal and another one is Shahjahan Sultan.
Sakamal and
Shahjahan.
Shahjahan. Where is Shahjahan?
Shahjahan's name is not Dialog,
Then
but Shah Kamal's name is there.
who is he? Are they related?
No, they are not related.
Huh?
They are not related, but name is Dialog in the Shah Kamal's.
Yes, Mr. Bowen, CD with PM,
Requirement.
with PM. With
Shah
PM,
Kamal
PM
is
report.
directly named. Number one.
No, not number one. So it will
English suicide group number one.
and case, the other case is case on 7, 8.
7, 8. We heard Mr. M.I. Hussain, a counsel for the petitioner, and Mr. D.D. will have state petitioners 1 and 2. Apprehend arrest. Filed this AB petition apprehending arrest in connection with NFI dated 2105. When was it filed? 20/2005/2023. Lodged by one Saidur Rahman as the informant. Most of the state FIR was registered as Fakira Gram PS case number 55 of 2023 under section 30634 NPC. Learned counsel for the petitioner submits that the brother of the informant committed suicide. He left a suicide note making certain absurd allegations against certain persons, including the petitioner number 1. Full stop. It is submitted that both the petitioners are brothers and they are not at all connected with any matter which may have led to the commission of suicide by the deceased. Most of the investigations have been initiated by the Ayuk. Petitioners are apprehended arrest and therefore to file the anticipated paying petition. Where Mr. B. D. Goyal and quickly submits that CD along with PM report is required. Accordingly, let CD along with PM report be called for. In the meantime, the petitioners are arrested. They shall be released on condition of bail bond of 30,000 each, with one local security would like amount to the satisfaction of the arresting authority. And subject to the following conditions, they shall appear before the IU within 10 days. They shall not have to tamper with the evidence or intimidate or influence any person or move out of the jurisdiction of Okinagram PS without written permission of the IU. If any of the conditions are found to be violated, IU is at liberty to pray for cancellation of the interim bail granted. Also, it is submitted by the learned counsel for the petition attached. Another AB petition arising out of the same police station case, i.e. Okinagram PS case number 55 of 2023 under section so and so is fixed on 7th of August. Accordingly, let this matter also be listed on 7th of August along with AB number
1911.
1911 2023.
Item 8,
Deliberation for the petitioner Vipulali alias Bolla Aliman. And the parallel has been shown that case was registered under section 395. And as such, case hearing may be necessary. Ma'am.
Petitioner is only one. Rootful.
Vipul alias Bolla Aliman.
He is not named in the FIR.
Yes, ma'am. At page 10, my lord, we have Bolla Aliman.
Allah is there, yes.
3.
Number 3. Third, petitioner apprehends arrest in connection with Ajob. PS case number 281 of 21 under section 395, which was registered on the basis of an FIR dated 4/3/2021, lodged by the informant. So where the petitioner was named as where the petitioner was named as an accused person. So it was alleged that the accused persons committed dacoity in the house of the petitioner and looted cash amount along with gold ornaments and issued dire consequences to the family members. So, Mr. B. Boy, please for the state. Let's see the call along with
21, if it is convenient, I will.
21 June.
Yes, Aju.
All right,
Aju.
21 June.
Yes,
Call.
Mark.
9,
That is the logic. The instant application is held under section 438 of CBC. I have a file holds of registered under section 376, 448 and 511 of IPC. Here the accused and the informant are already had a consensual relationship since very long time. And both the party, both the informant and the petitioner, that is the accused person, is a neighbor. And on the date of occurrence, the wife of the accused, along with some neighbor, and along with also the mother-in-law of the informant caught them red-handed. And like the informant out of shame has lodged the FIR the following day. And her husband also resides in Bangalore.
Revisional code, Now, these are the application under section 482. Now, these are revisions, Now, kindly see the paragraph 5, what the revisional code has said regarding the deleted. On 11/4, I'm sorry. Paragraph 5. On 11/4, an order was passed with the effect, that on perusal of the case record, it is found that while order dated so the court has directed the accused to appear along with the witnesses on the next day. And hence, from the same order, it could be derived that the accused has been allowed to produce his witnesses. And after so recording, the trial court again fixed on so and so. The defense evidence on the ground that it could not be reviewed weeks earlier or the day after. Kindly see thereafter with dates. The case has been fixed on so and so for defense evidence. Evidence of one defense witness was filed after cross examinations. DW1 has been charged on so and so. Lordship will kindly see how many dates has been given. And secondly, without your lordship will find that not a single word, either in a 330 or his statement, in the defense statement has been given. So the DW2, which is regarding relevancy of the accused, of the witness. Now, relevancy, the lordship will find that has been discussed with. And you see paragraph 10, that is at page 55. By the increased order details, it is seen that the learned additional CJM, after laying down the details, the various dates on which the cases were fixed for the defense evidence and discussing the provision of the section 250 rejected the prayer of the accused to reduce further defense. Evidence holding interrogated that considering the subsequent event and overall conduct of the accused, throughout, I am of the opinion that in fact, the progress of the trial and instant case, which is an old pending case of 2014. Furthermore, I have perused the evidence adduced by the accused and the statement of the record under section 313. This is now decision will not your lordship will find. That is at para 50. Para 20 minute is the relevant portion, para 20 minute. These are the things that the contract minute, which is in the relevant minute. Para 20 has been discussed regarding relevance minute. The coming to the requirement of the placing of the original contract number so and so that is between accused petitioner and the third party railway, admittedly the same contract was entered into between the accused petitioner and the railway authority. And the same has nothing to do with the check issued by the petitioner to respondent against the procurement of the construction materials. It has stated by the learned counsel for the petitioner accused that this original documents is required to show that payment for the work has not been released to the petitioner accused here, and as such the petitioner was not in a position to make the payment. Now, one hand he said that there is no debt and liabilities and legally enforcement, and one hand he said that because of this he could not pay the money. He is not getting a bill money. Can it be two fit in a two boats will cannot be. Now, it has been required to show that payment so and so. The petitioner accused was not in a position to make payment towards the material activity number so and the agreement dated so and so between the petitioner and accused. Respondent complained where clause 7 reads and 8 that the first party in lieu of the liability is handed over the second party 6 numbers of checks bearing number so and so. All of Allahabad Bank Villager branch so and so for rupees so and so both SBI Villager as a security for his liability, and the first party first to pay the dues of the second party within so the second party shall deposit the aforesaid checks in his account and recover the dues so there is nothing to show. The accused petitioner payment to the respondent was conditioned upon the payment to be received by the accused. The petitioner from the railway authority evaluated thus the futility of the allied defense to place on the record original contract number so and so is to be apparent. And rightly observed by the learned petition, decision no purpose will be served by production of the original contract document in the present. The reason given by the learned counsel for the petitioner of the purpose collect for the original contract document in the court as discussed above is found to be not convincing at all. Nothing has been brought to the record to show in what manner the production of the document would help the accused petitioner to defend the present case under the Negotiable Instrument Act, or how accused petitioner would be prejudiced if the evidence of the chain witness is not produced. Now, entirely this has been now, this is nothing is a delay tactic. Nothing. 10 years, it's going to be a decade for this which I owe money. 14 and 9 to are into 2023. Now, my lord, if your lordship allow again, my lord, what guarantee there is that they will come after this once they will file another application that saying that another so it will be never end this process.
With this finding,
Madam.
para 21,
Madam,
where is that agreement? Is there in the record?
there is a record is there, my lord. And secondly, my lord, there has to be a evidence to that fact. 330 nothing. My lord, the defense evidence nothing, my lord, regarding this.
Then goes on the record. Yeah, it is here. You can go through.
Yes. You can,
Agreement.
yes, agreement is also there. I have flag marking. It is between Loknath Prahlad and Krishna and King. There also, there's another, there's an RTA also which I flag mark also.
There are only two agreements. How
No,
many agreements?
one agreement.
One agreement.
That I flag mark, Mullah. That was for everyone, Mullah. There are 4 checks have been issued.
One is agreement dated January 13th. One is agreement dated January 13th. And the other is May 13th. There are two agreements here.
Maybe, I don't know, but what I have seen here.
This is the May one, second.
One should be made of 3/1/2013,
Yes.
which was notarized on 11/1/2013.
Mhm. Is there a specific date in the agreement that it should be paid on so and so date?
It is go by the agreement.
I don't see any date.
There's one more agreement that is 27/5/2013.
Yes.
Third party complaint.
Page number 59, para 21
My lord.
of the petition. Page number 59, para 21.
Yes, my lord. Last line, lord.
No, before that, this is an extract of the
Yes, my lord.
extract of the agreement
My lord.
that it used to be paid by 10/6.
Very.
As secured.
On or before 10/6.
It's a secured.
No, you have to read as a whole, below. That if you fail to so and so, that there will be a place below.
No, the clause says you will submit the bill on or before 31/5/2013. Clause number 3.
Page 59.
No, in your agreement. Page 59 is a reference to that
Okay.
clause in the agreement.
That the first party in lieu of its liability has handed over to the second party 6 numbers of debt paying so and so number so and so. So and so, all of the allowed billable grants so and so, check number so and so, both will be done as secured for its liability, and if the first party fails to pay the second party within 10/6/2030, in that case, the second party shall deposit the accomplished check in the bank to recover it. In the security checks.
Correct. So security check to be deposited if you fail to pay the bill
Yes,
on 10/6. That is the part of the agreement.
My lord, these are the advance payment, what I'm submitting.
Hmm.
These are the checks that was given as a security in anticipation of the completion of the contract and receipt of the amount, because the person has given the amount. He has invested in my contract. Contract is for 15 lakhs. And my lord, the statement is that not only 15 lakhs, he has given again another 12 lakhs. All these things are there. So it is secured, but the Supreme Court is very clear on that point, my lord. If it is
No, no,
anticipation of some transaction.
Question is that there is a legally enforceable debt so far as the respondent is concerned. Because he has given you some loan, you are supposed to give him back in terms of the agreement. Now, what the court is trying to understand is, what is the prejudice caused by not permitting you to present the DW2?
My
Because the issue is whether the contract is complete or not. If it is completed, you will be given a completion certificate. If the payments are released, let us say it is your case that it has released much later than the date mentioned in the agreement. That is be evident from your bank statements.
That record will be restored, that is, I don't know whether it has been paid or not. To my inspection, this has not been paid as yet. But my inspection told, it has not been paid as yet. And now the question of relevancy, my lord, whether this is the stage when the relevancy can be gone into. But it is basically, but lordship will kindly see.
No.
Lordship will kindly put up the dates, my lord.
The relevancy aspect is brought up because of so many dates given to you.
No,
There
therefore-
is a, the court has expressed a view that the whole purpose of you trying to get the second witness is a part of your dilatory tactics. That is the finding of the court.
No, that is what I submit, my lord, that this is not perverse finding. The
Why?
court has not taken the note of the 3 notices that I have issued, and pursuant to the first to summons a report has come, that it has gone to the Dhuburi. Then thereafter I have taken again, my lord, the summons have been issued.
Whether report has received or not, that has not been gone into, various dates have been sold, whether those are for reports or not, that we, and whether those are on my adjournment or whether on his prayer adjournment, letters of record. The whole thing is that what prejudice is supposed to him now, man.
His prejudice, he is not getting the money. The delay.
He is not getting the delay, I am not submitting on the, on the.
His prejudice is that.
Question. So, my lord, my whole prayer is now, my lord. Let there be a date, my lord, on that day, Lordship may direct them to issue directly, my lord, the available warrant, etc., and the person be produced, the matter can be ended. The whole procedural law, my lord, is for the, my lord, party, my lord, handmaid of justice, my lord, for purpose of, my lord, giving justice to the parties. My lord, in a similar case, my lord, the Natasha Singh case, my lord, if I refer to that, my lord.
When did you make your first prayer for production of the summons, for issuance of summons?
Lordship. My lord, on 6/11/2017. Court directed the petitioner to appear along with his witness. Fortunately, not on few dates, my lord. 6/11/2017, court directed the petitioner to appear along with his witness.
Where is that order?
I'm gonna the statement, my lord, the order is not here, but the record will reveal. From the various orders, it reflects.
6/11.
6/11/2017.
What does the funding impose?
Excuse of us, actually.
This was allowed as a last chance.
Yes, yes, now currently, then my lord, 13/3/2018, I have filed a petition to adduce the evidence of Nazimuddin, the person from the office on 13/3. He has filed objection. And 11/4/2018, Learned Citizen Dibrugarh allowed the petition. This order has not been challenged by them. 11/4/2018, page 24. Then 14/6/2018, 22/6/2018, I have taken steps. The report comes that it has gone to the Dhuri. So I again take 2 steps on 23/8/2018. In between this, that report had come with. And on 29/11/2019, Learned Citizen closed the defense. Procedural law, my lord, and that is the only weakness I am saying. My lord, the argument has been advanced. Thereafter, I file another application. There is no scope for that. I must get a fair opportunity to do it. Something which is not in my hand.
In the earlier orders, there is a direction for fresh summons, for whom the summons is to be issued.
To him only. To the PWD.
And when the prayer has been allowed, not, it's a duty of the accused. The defense witnesses to issue for that to procure the witnesses and to be present. However, by issuing summons, that is, pardon lies on me.
No, burden lies, but he is a government employee. How will he force him to appear? He doesn't come.
Now, how the.
That
this
is
is
for
why
the
he
court.
has-
That is for
He
the
has to
court.
take steps,
Right.
he takes steps and the court, under the side, senior signature of the. It's the duty of the court also, having been a prosecution is the duty of the prosecution.
Consider the, if the summons, if it doesn't appear, whether the available warrant go, then non-available will go, and whether even if it does not come, whether there may be a provision, whether for giving me to, allowing me to, whether submit the certified copy or the copy, authenticated copy of the.
No. This court has the power to summon the records of the railways if required. To come to a finding whether if any material available from the record, your
Yes, sir.
submission is, your submission is that the payment has not been made.
That was my instruction, madam. And the relevancy of at this.
Because admittedly, there is an application saying that I want so and so as a witness. The address has gone to some other place, it has not come. There are several dates taken by either parties or both parties in the meantime. Now, if we remand it back, the question would be again for issuance of summons. Then if he doesn't appear, then the other processes. Ultimately, the matter doesn't get hurt.
But the directly trial court to requisition the record from the office. What is necessary?
You give us the details, particulars of the records,
But,
give the particulars. We'll direct them.
That was neither in the political, this court has the power.
Page 58, some particular.
That was neither in the political, this court are there.
You give us or we dismiss your petition, as simple as that. You tell us that these are the records which are necessary from the railway.
This is mentioned on page 58, paragraph 20.
Page
Page 58, paragraph 20.
58. Paragraph 20.
20, paragraph 20, last paragraph, page 58. Coming to the requirement of placing the original contract number so and so.
What records do you want? The contract.
That is the contract, the records of the contract.
So for what purpose is it required? In respect of payments required to be made to him or not?
But this will contain in the office, everything will contain there.
No, for what purpose? This is not a dispute pertaining to interpretation of some clauses of the contract. This is a case where he says that there is a legally enforceable debt, therefore I have come before the court. You want to say that the payments have not been released.
It is not legal,
You say it is not legally enforceable.
enforceable date. For that purpose, not all this, what my submission are, that is relevant. But at this stage, whether this will be relevant,
No, whether this will be relevant is to cut short the delay.
that is there, that is there.
Then we cannot be unmindful of the delay.
Logic, the fixed date, the trial court will requisition the record or the person.
For what purpose you have to tell us at least prima facie for the contract to be produced. What will the contract project? This contract is between you and the railways. He is not a party. Are you a party in the contract?
It is the record, it is the record. The record.
No, it says placing the original contract, number so and so. That's all.
Yeah, this one the court has said, but then some particulars are achieved by that court, so I'm particular. But the summons were my lord means
Again, paragraph 21, place the record of the original contract document. 22, original contract document.
as rightly observed by the learned editor, there is no purpose with it, so by producing the record. That is another ground matter on which I am saying, at this stage, whether it was, the, within the power of the court, look into the relevancy of the, particular witness or the documents. And on that matter, I am relying on, the judgment of the appellate court also, that is not the stage at that time,
Which judgment? 2013.
One is 2013, I am on the fair opportunity to me, present my case. I am referring to paragraph 15.
This is on the Prevention of Corruption Act.
Paragraph 15
Of
of this 2013 CLJ 3346.
3346.
3346. Paragraph 15. Fair trial is the main object of the criminal procedure, and it is the duty of the court to ensure that such fairness is not hampered or taken in any manner.
Paragraph
Paragraph 15.
15. Yes.
Fair trial is the main object of the criminal procedure, and it is the duty of the court to ensure that such fairness is not hampered or taken in any manner. Fair trial entails the interest of the accused, the victim, and of the society, and therefore fair trial includes the grant of fair and proper opportunity to the person concerned, and the same must be ensured as this is a constitution as well as a human right. That under no circumstances can a person right to fair trial be jeopardized. Producing evidence in support of the defense is a valuable right. Denial of such right would amount to denial of a fair trial. Thus, it is essential that the rules of procedure.
No quarrel about it. No quarrel about
Yes.
this proposition.
So, I want that the person should come under the document.
What to
Yes.
depose about what? The contract agreement.
Following this manner, following this.
This contract agreement is between you and him. There is no, is there a dispute that there is no contract? See, there are two contracts or two agreements. One with the respondent, one with the
Many
railway.
aspects, one of the aspect, though I am the contract is for 15 lakhs. Now he has invested 26
It's
lakhs.
between you and him. The contract with the railway doesn't include him.
So my lord,
The contract with the railway would be that on such and such date, such and such contract was awarded. This is the stage of the contract. This is how it was closed. This is the measurement book. This is the payment made. This is all. What agreement you had with him on which date you are required to pay, whether it is for security, whether it is in terms of your commitment that you will make payments to him on such and such date is, how is it, how are you going to prima facie, how are you going to support your case with the contract?
this, as the order has not accepted itself, that these are given for security. The order itself has.
Security, yes.
Yes, security.
Reference to the agreement that on such and such date you will have to make the payment.
Security. So security, my lord, is an agreement, my lord, as a purpose of security that has been given. This cannot be, my lord, for the term that is a legally enforceable date. If at all, if at all required, my lord, the agreement has to be enforced. Agreement has to be enforced. That is one thing. But secondly, my lord, the advance payment. And if the ultimate, my lord, the object is not achieved, in that case, that will again, my lord, cannot be said to be, my lord, legally enforceable date. So these are the things, my lord, which need to be, my lord, approved.
Okay.
Now, following the judgment, my lord, the second one I have given, my lord, AIR online 2022 Delhi, my lord.
Hmm.
184.
Yes,
Then relying on paragraph 5, 6, and 7. In the present case, it is noted that the petitioner had initially sought to cross-examine both the parents of the deceased on one day. However, the prosecution subsequently chose to drop the murder of the accused, that is PWP, from the area of witnesses. It has been informed that till date, only one witness has been examined and the other witnesses are yet to be examined by the prosecution. Doubtless, the petitioner in the present case had ample opportunity to cross-examine the opposite witnesses, but he did not utilize the same. Be that as it may, this court cannot lose sight of the fact that a fair trial is the hallmark of criminal procedure. It entails not only the right of the victim, but also the interest of the accused. It is the duty of every court to ensure that fair and proper opportunities are granted to the accused for just decision of the case. In furtherance of the above, reducing of evidence by the accused in support of his defense is also really right, and allowing the same is in the interest of justice. Keeping in view of the aforesaid and considering the fact that the petitioner has been charged for offense punishable under section 304 of the IPC and witnesses Vinod Kumar Chauhan is the father of the deceased, this court deems it apposite to grant an opportunity to the petitioner to cross-examine the aforesaid witnesses, subject however to cost of rupees 5,000 to be deposited by the petitioner with the Delhi State Legal Service Authority within a period of 6 weeks from today. On deposit of cost, the trial court shall summon the aforesaid witnesses for 1 day, on which date learned counsel for the petitioner shall conduct cross-examination and no adjournment shall be granted at this stage. Then, my lord, the third one, my lord, I am referring, my lord. They are online 2022 Supreme Court 244. There's one page judgment. My lord. Paragraph 2. We will find that the trial court as well as the high court have gravely erred in law in not permitting the defendants to produce document the relevance of which can be examined by the trial court on the basis of the evidence to be laid, but to deprive a party of this to the suit not to file document even if there is some delay will lead to denial of justice. It is well settled that rule of procedure are handmaid of justice, and therefore even if there is some delay, the trial court should have imposed some cost rather than a decline the production of the document itself. Based on this, my submission is that the chief will fix a date, the trial court may be directed either to requisition the documents or the witness.
one more question. This is an agreement between you and the railways for production of the contract agreement. The contract agreement is also available with you. Copy of that, bound to be available with you because you are one of the contracting parties.
Very sure whether it is available, but otherwise normally it should have been.
Should have been.
Should have been.
So
But
from the
again,
contract,
reducing
if you
personal
can,
fee.
from the contract, if you can show us that yes, this particular clauses are relevant, which will determine the consequential action on which your commitment to the respondent is to be or is not to be exercised.
My submission is that relevancy can be considered only
Ordinarily, yes,
after.
but in a matter of this nature, you see the number of years that has gone by.
So where is my posing the question, where is my fault, madam? I have
You see the orders on which the number of times the adjournments have been taken
Gotcha.
by the accused,
Gotcha.
with steps or without steps. How do you say that you are not
These
responsible?
These are not under challenge before the court, madam. These are not under challenge before this court. Madam. Of course, madam, the submission was made on after his appearance in this court, the matter has not been listed.
No, I'm not talking about this court, I'm talking about the record available here.
They also have taken the Malad record, Malad on 244, Malad, he filed Ukalatama and the matter was listed on 85.
And what is the judgment that you want to refer to, this order of Supreme Court?
That is in reference to that, this suo motu petition whereby there's a various orders regarding because there's a floodgate of this NI data which.
There is a set of guidelines.
Guidelines, that is one of the this thing that NI cases because it takes about 13% of the indisposed cases as of now. That is why regarding NI cases, these cases will also be find on the site also. It has been directed that particularly the special banks has to be constituted immediate release. And now here is a case with 9 years because and see whether The question will be whether, my lord, whether the, my lord, that will be the argument he can place it. The contract also, my lord, and your lordship has to see the conduct of the opposite, the petitioner also. Kindly see the 313 statements, kindly see his evidence, nothing, not a single word. See, if you say something about that yes, I can understand. Now tomorrow again you will come in and say that so and so is irrelevant. It cannot be permissible. Yes, there should be a fair trial, I agree, fully agree with that. But not this way. This is nothing, Miller. This is a technique, delivery technique, Miller. 9 years. And 2012, the contract, and he stayed in the bar that he's not getting the money as of now. Miller. Is it possible? Either if he is not getting the money, that means he's a blacklist of contractors, and his conduct is a different one.
That is on the merit, only one point I submit the checks were presented after 3 months. That is another merit is there. So the validity period has already expired day after he has presented. It is one of the argument I will be making. That he has right to say he will never get the money because he knows that it was presented after the validity of the checks. And it is not the we are not on the merit of the cases. My whole thing is that once the court has permitted me to reduce the evidence of that particular BW, accordingly, dutifully, I have taken summons. Wrong submission of the summons to the different person, that cannot be attributed to me. So far as the third summons is there, the record is silent. What had happened to that? The court has abruptly closed the evidence. It's my valuable right. Though he is entitled, I have also to part with such amount. So it has to be therefore the judgment I have cited. The prejudice or the arbitrage, whatever it has to be taken in both the sides. It is already delayed for 10 years or so. So in that case, another date will not prejudice him at all. If required, some cost may be improved. And as already said, the court will directly summon the particular records. And this has shown disallowed to reduce my evidence. I lose my valuable right to defend my case.
Okay. For orders on Tuesday. Tuesday.
The other chief matters are
All the similar, same.
This is 11, 12, 13, 14.
14.
only cases number will be different. The dates are head of the Indian orders of.
Much good.
Item number 15,
Right.
Working on proper place test number 91 of 20 and they are 23 720 is the under 366 starting from I. Here looking the informant victim girl and accused person all are
Where is the FIR?
and this 9.
Yes. What is the name of the petitioner?
Petitioner number 456 are accused.
4, 5, 6.
456 accused.
Huh? You're referring to the FIR at page 9.
No,
Page 9.
just 9.
Ah. Then where is petitioner number 1?
Okay,
What is it, comment?
Huh?
There's a joint petition from.
Joint petition.
Yes.
Okay.
petitioner number 1 is the information. Petitioner number 2 is order of victim girl. Petitioner number 3 victim girl. Petitioner number 4, 5, 6 are accused of. 95.
3 is the victim girl.
He is the
victim.
they compromise the case. Where it remains the page 19 Mutually.
Where is the agreement?
The agreement is 19.
Yes, madam.
Since the matter is been resolved within the parties of the president of Lakshmi Nagar reported in 2019. They have been agreed upon.
We heard learned counsels of the parties. This criminal petition is filed by. This is a joint criminal petition filed by the informant and husband, the victim girl, and 3 accused persons named in the FIR. What happened to the other 2 accused?
Consider only again. If it take it first.
1, 2, and 3.
1, 2.
The learned counsel for the petitioner submits that an FIR dated 7/8/2023 was lodged by the informant. Who's the petitioner number 1 here? Whose it was alleged in the said FIR that the persons named in the FIR, including the present petitioner's number 456, had forcibly kidnapped her niece. So after hearing the hue and cry of her niece with the help of Kopu police station and 5 other family members, she was rescued from the house of one Kusum Mili of Raunamuk village. The accused persons named 1, 2, and 3 fled away from the house of Kusum Mili after seeing the police and other family members. Also, the said FIR was received and registered as Boku PS case number 291 of 2020. Under section 366/34 IPC. Stop. Pursuant to the investigation, the charge sheet was filed by the IU by the charge sheet number 260 of 2020 dated 21/12/2020. Also, the petitioners 4, 5, and 6 were shown. As persons, as accused persons. The other accused persons mentioned in the FIR were not put up as accused persons. Full stop. Meanwhile, the petitioner, the accused persons named in the FIR, accused persons 1.3 named in the FIR, and who have been charged sheeted. And the petitioner entered into an agreement, and a mutual agreement was executed on 19th of June, 19th of January 2023. Also by the said agreement, which was jointly executed by the present petitioners, comprising of the informant, her husband, and the victim, alleged victim girl, as well as the accused persons named in the FIR, accused persons number 1.3 named in the FIR. Also, it is submitted that the informant and our family members, including the accused persons, as well as including the alleged victim girl and the accused persons, have mutually settled their differences. Also, it is stated that the first party in the agreement, namely one Bolin Pegu, who is Bolin Pegu? Father, who is Joan T. Pegu? The father of the victim girl exaggerated the matter and wrongly stated certain facts, and the FIR was therefore based on wrong information. Learned counsel for the petitioner, referring to the sale agreement, submits that in spite of this was produced before the IO. No, this agreement. That in view of this agreement, there was no cause for the IO to proceed in the matter and file charge sheet. The court has also taken cognizance in the matter by the order dated 29/12/2021. In ERC number 133 of 2021 by the court of SDJ and Kothur. Also, being thus situated, the present criminal petition has been filed. Notice has not been issued. Notice has not been issued.
Before the general. You get the informant. You get the informant. We'll issue notice to the informant. During the course of the hearing, we see that although the interim order was granted, staying in further proceedings of so and so case, it is found that no notice in the matter has been issued. Accordingly, this court of appeals considers it appropriate to issue notice to
the respondent state, enabling them to respond appropriately. Full stop. The informant MS so and so is also directed to be served a notice causing her to appear before this court. Steps be taken on the informant within 1 week from today by registered post. Dusty is also permitted. Least after 2 weeks.
The informant there is it is not.
You're appearing for both.
No, joint. The Bina or not, we can have.
Petitioner number one is very complicated.
How can you file a joint petition? How can you file a joint petition? Hmm?
After agreement, after compromise, that part of the Supreme Court decision. That's why Gyan Singh and Narendra.
You should have appropriately, you should have made her a party, let her appear and make a submission that yes, we executed an agreement. Matter could have been closed. Here they are not living as husband and wife. In this case, they are not husband and wife. All right, you strike out the notice part. In view of the statements made by the learned counsel, supported by an affidavit. Who has filed the affidavit?
There is no fight. Jointly filed.
The petition has been jointly filed by all the by three of the accused as well as the informant, the victim girl and her father. In view of the submissions made, this court considers that since the parties have resolved their dispute and does not want to proceed in the matter, they made in the petition is allowed. The proceedings relating to POCO PS case number 291/2020, presently pending as PRC 133 of 2021 under section 22, pending before SDGM M POCO Viswanath is hereby set aside and quashed. Criminal petition accordingly stands disposed of in terms of the evidence.
Main hearing BA item number 16.
Yes. Sir, this was 39. There are two petitioners not arrested on 24th of 2020. Not as on date 46 days behind the bar. The FIR lordship will find at page number 12. Mary,
302.
302. Mary,
Yes, please.
with reference to the subject cited above, I have the honor to report for you that I am forwarding. I'm sorry. The respectful submission is that today it is almost 5 years while my father was alive. My younger sister, Husainara Khatun, was given in marriage to the below noted accused number 1. At the time of marriage, the below noted accused number 1 equate a 1 kata land and a fishery as mentioned in the register. Since 3 days after the marriage, the accused persons and accused number 1 have been torturing my sister both mentally and physically. Hearing the same, my sister has been continuing to conjugal life with the husband. In the meantime, they hit my sister with brick and besides giving fist and kick blow. They laid upon her chest with the intent to kill her. Later on, having come to know, we got my sister medically treated and when she recovered a bit, accused number 1 took her to his house. Again on 27 June 2023, when my younger sister became senseless after being beaten by the accused person, they never took her to Dhubri hospital. But the accused persons rendered no treatment. Being helpless, I brought my widowed mother to Dhubri hospital and admitted my sister here and rendering medical treatment to her. In the meantime, I came to know that the accused persons are threatening that they would file complaint against us. So initially, my lord, the case was registered under section 498A, but in course of treatment, my lord, the deceased died, my lord, and subsequently 302 was added. So the informant in this case is the elder sister of the deceased. So the actual fact of the case is that, my lord, she was suffering from various ailments since earlier, and that she was also a pregnant lady. So on the date of occurrence, my lord, that is on 27th 2023, my lord, when she got some complication, my lord, and then she was admitted in hospital by the accused and petitioners. And in course of treatment, my lord, they were in medical, my lord, for almost more than a month. From 27th, my lord, to 22/4/2023, she had been under treatment. So initially, she was admitted at Dhubri Hospital, my lord. If your lordship is pleased to peruse the annexure 3, that is the medical sheet, my lord, that will show that from 27/3/2023 to, my lord, 22/4/2023, she has been under treatment. So when, my lord, her condition was deteriorated, my lord, then she was referred to GMCH. But unfortunately, my lord, instead of taking her to the GMCH, my lord, she was admitted in the, my lord, Fakhruddin Ali Ahmed Civil Hospital, Corbett. So that your lordship will find in the, my lord, the report of the IOM. That she was taken to, my lord, the Fakhruddin Ali Ahmed, my lord, medical hospital. If your lordship is pleased to peruse page number 60, my lord, that is annexure 4.
Yes.
Yes, my lord. The relevant portion your lordship will find from the last paragraph, my lord, from the bottom, my lord. So during investigation, available witnesses have been examined. Page number 60. During investigation, available witnesses have been examined and visited the PO and also statement of victim Husainara Khatun. The injured Husainara Khatun referred to GMC, Guwahati, but the accused Surab injured Husainara Khatun admitted at FAMC Hospital, Corbetta on 20/04/2023 for treatment. On 22/4/2023, the injured Husainara Khatun died at Fakhruddin Ali Ahmed Medical Hospital, Corbetta. After the dead body inquest by the circle officer, Mr. Kanjal Gora of Corbetta, and also holding PM examination of dead body. After holding PM examination, the dead body handed over the actual gazette. The cause of death, doctors opined. This is the, my lord, medical term that has been here put in the report. That doctors opined PE 24 days to post expulsion at 24 weeks, this time with septicemia and cardiac disease. So this has been told to be the cause of, my lord, the death of the deceased. So annexure 3 would show, my lord,
these are the series of documents, medical reports, etc. You know, that she was a pregnant lady. And she was admitted,
This PM report is from where?
my lord.
Volpeta.
Yes.
The findings you read
Yes, my lord.
are with regard to PM report.
Yes, my lord. No, it is, my lord, from the report of the IO, my lord, where he made the prayer for addition of the section 302, my lord. And in that, my lord, he stated all these things. This is the report of the IO, whereby he made the prayer for adding, my lord, 302, when the deceased died. And so far as the, my lord, the injury report is concerned, it also speaks of that she dies out of some, my lord, disease, my lord. So this is subject to the metrics in the diary report as well as in the PM report. But my respectful submission would be, my lord, that we have been with the deceased, my lord, for more than a month, my lord, in the medical. The medical slips and other reports also would indicate that, my lord, we have the attendance there. But the fact is that, my lord, this is the second wife of the petition number 1. And that, my lord, when she died, my lord, the elder sister of the deceased, my lord, she came with all these allegations that we did not provide any medical treatment. But if your lordship is pleased to, my lord, peruse this 60, my lord, it also speaks of that, my lord, the deceased was admitted at the hospital, the Alian hospital, my lord, by the petitioner before the lordship. And that is the cause of death, as reflected here, my lord, in the IO report of the IO, my lord. It also shows that she was suffering from septicemia and, my lord, the cardiac disorder. So, my lord, the allegations are false, and that, my lord, immediately when we were also aware that she is a pregnant, my lord. Therefore, we immediately took her to the hospital. Because, my lord, the as stated in the FIR, my lord, that she was taken to the hospital, the neighbor. It is also false, my lord, and that after that, the informant also went there in the medical, but no medical.
What is the name of the victim?
Victim Hussaina happened. First, my lord, I have got one case of the injury report, my lord. Your lordship will find at page number 64. That also says the no external injury seen at the time of examination. So in terms of the injury report also, the allegations stands to be false, my lord. Because if we have, my lord, tortured her and subjected to, my lord, physical assault, etc., my lord, as alleged in the FIR, definitely there would have been some injury mark on the body of the deceased. We also regret that, my lord, the untimely death and departure of the deceased, my lord. But the so far allegations concerned, my lord, the allegations are totally false. And earlier occasions also, my lord, and since she was, my lord, suffering from ailments, my lord, she was provided with, my lord, required medical treatment. Petition number 1, my lord, 70 years old. He has been in the jail, my lord, since last 45 years.
There are 2 medical reports, right? This PM report.
PM report.
PM report says some injury.
Yes. Some injuries found, my lord, and that is, my lord, the cause of death, my lord, that is. Yes.
Blunt force. Blunt force it is not described in the. Doesn't show any injuries there.
The statement of informant and my lord, some witnesses, they were not happy. The victim and my husband, my lord, they were not happy. So. Small gap is between them, my lord, while going on.
You see the report again?
Another injury report also there.
Another injury report is here.
Yes, that is there. I have seen.
So this report you go through, see. First PM report.
Because we don't take it. Deceased has been the second wife of the petition number 1.
So
So that will not, when they died with her. The family members will not, more particularly, this other lady of the deceased is not have here complaint. The elder sister went into the police station and brought all this element. That will not, we were here with the deceased will not see the last moment of her life. It should also indicate that we not going to. There is no problem to our part, or we never neglected to our medical treatment as well as we did not.
where is the medical report saying of mentioning she was
From
pregnant?
28. 3 million.
Page number?
His number will not annexure 3 or what you will find. Will not be, it starts from his number 23. 22 onward, will not be what you will find all the medical which I have.
No, you referred to some document to say she was pregnant.
Below. You also will find at page number 29. 28 is the type of below.
Well, what is the report of the investigation?
28 below. If you worship is to go through the type of below. Then the third line says below, give clinical note of page 28. Brief clinical notes, RSD, pregnancy 5. Number 28. Number 53 also speaks that she was pregnant. Maybe that she had got some bleeding.
Yes, Mr. Wood.
This is one of the report below. The single page I have submitted below. This is the original below. So here is also below one of the accused, who is the son of the below petition number 1. He has been shown to be an attendant in the medical. Yunus has also been made as an accused. Accused number 6 in the FIR. So the report says that he was one of the attending lot. But the informant says that we did not provide any medical treatment.
Complication was there, my pregnancy.
But no injuries are sustained.
No, injury area not mentioned.
PM report says injuries, but it doesn't indicate where and what. You take this back. I'd learned counsels for the parties. This bail application is filing a petition is one and two. Bringing for bail as they've been arrested in connection with Fakirganj police case number 78 of 2023 under section 498A. And so subsequently, section 302 was added. Also, they submitted by the London Council for the petition that an FIR dated 12/4/2023 was lodged by the informant. One Jahanara Khatun, making allegations against 8 persons shown as accused in the FIR, including the present petitioners. So it was submitted that in the FIR it is alleged that the deceased was the younger sister of the elder sister of or sister of the informant, who was married to accused person number 1. Is alleged that the deceased was married to the accused about 5 years ago. And since soon thereafter, the accused person started torturing her sister mentally and physically. It is alleged that the accused persons had assaulted the deceased with bricks besides assaulted with bricks as well as physically and thereby physically causing injuries to the person of the deceased with the intent to kill her. So when the informant came to be aware of the assault on her sister, she was medically treated, and when she was recovered, the accused number one took her to his own house. Again on 27/3/2023. The deceased became senseless after being beaten by the accused persons. And then the neighbors took her to Dhubri Hospital. Full stop. There in Dhubri Hospital, she was being treated, and subsequently she expired. Also, in connection with the investigation of this particular so case, so police station case, Fakirgan, petitioners were arrested on 24/04/2023. What was the age of the deceased? What was the age of the deceased?
45 years, you know, it has been written in the one of the medical speaking. The Lordship will find it as number 20.
The counsel for the petitioner submits that the conjugal life of the deceased and the petitioner number one, there may have been differences in their conjugal life between the petitioner number one and the deceased, but the allegation that they assaulted and ultimately assaulted and causing injuries which ultimately led to the death of the deceased is totally incorrect. Full stop. It is submitted by the learned counsel for the petitioner that the deceased expired because of complications which arose as she was pregnant for some weeks. So he is referred to the medical copies of the medical documents available in the petition to submit that she was taken for treatment to the Fakhruddin Ali Ahmed Medical College Hospital in Borpeta. And during her treatment, while undergoing her treatment, she expired. Also, the allegations that the petitioners had assaulted and caused injuries is totally false and incorrect. Also, this court, by a earlier order, had called for the CD along with the injury report. Ghana APP has produced the CD today along with the injury report and the PM report. Also, the CD has been carefully perused. Upon the perusal of the CD, it is seen that the PM report indicates that the death was due to so and so, X-ray, the opinion. That was due to shock and so on, resulting from septicemia. However, there is another injury report available in the case where which was issued by the Dhubri Medical College, dated 26/4/2023, which shows that no external injury was seen at the time of examination. So, the inquest report also does not reflect any injuries, external injuries on the deceased. Also, the PM report also does not indicate, does not refer to the injuries, does not refer to the, does not refer in detail to the injuries suffered, sustained by the deceased, except in the opinion, except as reflected in the opinion. Also, the statements of the witnesses have been examined, and specific statements incriminating the petitioners at this stage of investigation are not noticed from the scene. There is also no material in the CD to suggest that further custodial detention of the petitioner is necessary at this stage of the investigation. Taking into account all of the above, including the period of detention undergone, the bail petition is allowed. The petitioners are directed to be released on bail upon furnishing a bail bond of rupees 40,000 each, with one local security of life to the satisfaction of CJM.
CGM Dhuri.
Dhuri. Petitioners will continue to appear before the IU on each and every day as required till furnishing of the till completion of the investigation. Petitioners shall not leave the jurisdiction of Fakir Ganesh PS without orders, specific orders from the competent court. The bail petition is accordingly allowed and disposed of. CD returned.
Item 17,
That I was. The extract to the report, PM report.
Main visual. This is a fourth and very picture and also the allegation under 341, 326, and 307 of the Indian Civil Code. The document highly favors the entire page 12. May I read it?
Yes,
I beg to state that on 34th, the 26th Sunday, around 10:15 in the night, I see Jogi, who was approached many times by Sri Rampu Ali, with sharp weapon into which a lot of direct result. The boy had tried to kill me on previous occasions, but also threatening me that there is law in his residence. In the meantime, I was medicated to the Hatinga police station in the DHC. And big day to the appropriate action will be taken against the boy. Now you have to register under section 341, 307. Lordship, kindly peruse Annexure 50, the forwarding report. The forwarding report, you will see the very first times. May I read you? This will reference the subject cited. You have the honor to forward during the very person who has been arrested in connection with the case with a prayer to keep him in jail as well to enable me to complete the investigation of the case. So from the very first day, he was in jail. You will see. Now you will see another part in the D point here, C point. B point also during the course of investigation. During the course of investigation, one sharp knife has been recovered and seized from the person of arrested accused person. So, my good submission here also is he is already behind the bars for last 38 days. The knife, assuming but not admitting their knife was used, but they have been recovered. And the true fact here also that we all are friends. On that particular day, we were partying here also. There was a tussle and he tried to attack a friend. The informant tried to attack a friend of mine. In between, we received injuries. He was also injured. I had to receive injuries.
What is the name of the petitioner?
My name is Altaf Ali, alias Rampo Ali.
Yes. Anything?
From medical report, my it shows the case of K24.
So
It's a non-bailable offense, but maximum punishment is 3 years.
the investigation also not complete.
That is my that the injury report correct, my arrested.
We heard learned counsels for the parties. Which well, bail petition is filed by petitioner. So and so. Seeking bail in connection with Party County case number 166 of 2023 under section 12. Also, petitioner was arrested on 1/5/23. And since then he's been in custody. We submitted by the Learned Council with the petition that's FIR dated 1/5/23 was lodged by the informant on Jagadish Gogoi, making allegations that the petitioner, who was the accused person, who had assaulted the informant with a sharp weapon, causing injuries. And had threatened him. Also, because of the injuries sustained, the petitioner, the informant was treated in GMCH through the Nottingham police station. Also, it is submitted by the Learned Council to the petitioner that there was some quarrel with the informant, but no assault as such was caused. As alleged in the FIR. Petitioner submits that the informant and the petitioner are known to each other since several years past, and no such enmity exists between the petitioner and the informant as alleged in the FIR. Correct. None of APP has produced the case diary. Most of case diary produced have been carefully produced. From the injury report, it is seen that the injury sustained by the petitioner informant is stated to be simple. The matter is under investigation and investigation is progressed. The statements of the accused persons and other witnesses have been recorded. Considering the progress of investigation carried on, and also in the absence of any specific materials which incriminate the petitioner at this stage of materials to suggest that release of the petitioner at this stage will cause impediment to the investigation carried on. This court is of the view that a prayer for bail can be granted. Also, no materials are also seen to suggest that the release of the petitioner on bail at this stage will hamper the further investigation. Accordingly, the petitioner is released on bail upon furnishing a bail bond of ₹25,000 to the with one rupee security of like amount to the satisfaction of the CJM. Kamru, Metro. Also, petitioner will continue to appear before the AIU as and when required till completion of the investigation, and the petitioner will not move out of the jurisdiction of Hatigaon PS without written orders from the competent courts. Bail petition is accordingly allowed and disposed. Serial.
Andeep, you have
Item 79, 19,
CD one, that is the one I want.
Yeah. And that, Please stay with the adopted and qualifying will be made by the informant. Like what I have been started, statements in the with the false logic. And this informant happens to be the sister-in-law of petitioner number 1. Is the petitioner in this case, and 19 we are the because of a property dispute over the plot of land, the present that had been lost. There is law that it will be able to allocate back.
Where are the other accused persons? What happened to the other accused persons?
Lordship,
Maybe my lord, next petition, my lord, item number 19, they have filed a
yeah, that's son, Lordship, son of.
Some materials are there. There are some materials, madam.
Lordship,
There are some materials in the CD against you.
again, Lordship,
Not a case for bail at this stage. Some materials,
Yes, main accused, my lord, they are Abdul Ghani. Main allegation is against him. Others, my lord,
no, we are with the bail application.
yes. But now Abdul Ghani, that is, yes.
Third, the counsels for the parties, this the petition is filed by so-and-so. Seeking bail.
Look, only for- let's see. That's the people who take it. Thank you. Yeah, fine, yeah.
It is submitted by the council that the petitioner is seeking bail as he is arrested in connection with Ajopi is case number 342 of 2023 under section 4. Petitioner was arrested on 15/5/2023. Since then he's been custody. Post it is submitted that an FIR dated 9/5/23 was lodged by the informant one, by the informant. Name deleted. Name deleted. Informant. It is submitted that we say in FIR it was alleged that the accused persons named in the FIR, including the petitioner, had entered into her house and assaulted her and the other members of the family who were in the house, attempting to strangulate and kill her. Also, there was an attempt made to rape the informant also. Upon the FIR being registered as Ajopi case number, so the investigation in the matter proceeded. The learned APP has submitted the case diary. Case diary produced has been carefully produced. Then the case diary, the statement made by the informant under section 164 CRPC is available. There is the statement reads that she has clearly implicated the person petitioner also. The informant, however, refused to undergo medical tests, which is endorsed accordingly by the senior medical officer, forensic department, forensic medicine, medical college. The result of the case diary reveals that the statements of the witnesses have been examined. what do you present on the witness, materials available? Like, if there is a the case diary to see that the matter is still under investigation and charge sheet in the matter has not been filed. At this stage of investigation, case diary reveals materials which incriminate petitioner. Also. Considering the allegations. Considering the gravity of the offences alleged. And the stage of investigation which is being carried on. This court does not find this to be a fit case. Grant bail at this stage. Accordingly, the petition stands rejected. CD returned. Then AB petitions when. Heard letter counsels for the parties, this petition is filed with the petition 1, 2, 3, 4. Apprehending list in connection with. Agopi's case number so and so, under section so and so. It is submitted by the learned counsel to the petition that. The petitioners have been named as accused in a FIR dated 9/5/2023. Filed by the informant. Also, it is alleged in the FIR that the accused persons had broken into her house and assaulted her and the other family members. And attempted to kill the informant by strangling her neck. Also, an attempt was also made to rape the informant. Also, upon receipt of the FIR and registration, and upon being registered as his case number so and so, investigations proceeded in the matter. The learned APP has produced the CD. The CD produced has been carefully produced. The matter is still under investigation. This court considers it appropriate to grant interim bail to the petitioners. To cooperate with the investigations that has been carried out accordingly. The event of their arrest in connection with so and so case, petitioners have been enlarged. The petitioner will be granted interim bail upon furnishing the bail bond of rupees 30,000 each with 1 rupee security of like amount to the satisfaction of the arresting authority and subject to the following conditions. They should appear before the IU within 10 days. They should not hamper or tamper with the evidence. They should not attempt to influence or intimidate any person. They should not move out of the jurisdiction of the other peers without written permission of the IU. Let the updated CD be produced by the IU. On 7th August, 7th updated study.
Supplementary list, item 42.
Due respect, Lordship. Lord, prepare for bail application for 39 Lordship. Soon as case Lordship. In connection with page number 8 Lordship, is a higher Lordship. Now, petitioner was soon as from 11, yes, 59 days.
So during PIT, the informant identify the accused person. Informant identify the accused person.
No, something to do with charge sheet or something. What instructions were you?
Instruction, my lord, because this person was thrown away, he is a habitat offender, my lord. He actually, gave people near the bank after administering them with some success, my lord. So in this particular case, my lord, police were searching him. In the meantime, he was arrested in different case of similar nature, my lord. So, my lord, TIP was conducted.
Hmm.
So last occasion when the letter was literally worship has directed me to take instruction whether regarding the status of PIP. So now it has been that maybe the PIP was conducted on 19/5/2023 and the informant has identified that person. So he is the active.
Charge sheet not filed.
Trust it on file, it is here.
When was he arrested?
11/4/23.
60-day offense.
Yes,
Yes.
Then how many days?
59.
Sixty days will be on 11 or 10.
And it's not 11/4.
So 60 day will be on 11/6 or 10/6. Charge sheet not filed. Well, what instructions you have got? So
Yes. Just on one is not was arrested or was shown arrest 11/4/2023. But in description of this, the PIP was done 19/5/2023.
1 month gap.
He is identified.
Identified my God, but 1 month gaps.
So there is some procedure with it.
After 1 month lordship, any case may be developed, cooked up story lordship.
Anything can
And
happen.
now lordship, there is no direct witness lordship. As per direct FIR allegation lordship, 20 or 25 years stated talking about him to after 20 to 25 years boy lordship. As per FIR stated lordship, the informant lordship. The informant is his victim's son's lordship. And now lordship, the investigation officer has 56 years. He will be contacted. The FIR version and EAD version, they may be different. Now lordship, really 59 days lordship, 56 years. Condition may be imposed lordship.
What happened to the judgment in the Supreme Court? Some matter was referred to a larger bench.
Yes, that has not been decided. Regarding the period matter.
What do you say with his regard to default bill?
Yes, it is yet to be completed.
When will it be completed?
Tomorrow.
I think it will be on Saturday,
Saturday.
10th.
10th.
Or 11th, maybe.
I know.
April is practically ending.
Today is 58.
58. So on Saturday.
Obtain the order copy. The
No, obtaining order copy is not included there.
58 is not. 59 is not. Or 60 days.
Please try to approve after
Third,
today.
all not.
51
The
days.
main case was already run it board below granted bail lot.
Who?
Yeah.
Which matter?
FIR case number 95 only 23 lot. I have already supplied. Already given lot. Just already given.
In the matter where you were shown arrested.
No,
Earlier first case, initially, under this case, while the police were investigating this case, he did similar kind of offense in another case.
Where he was arrested.
Here he was arrested.
We posted on Monday. Monday.
Monday lordship after 60 days.
Doesn't matter, you're right. We'll see your right on 60.
Then we'll approach the lordship, planet court below lordship, prime court maybe.
Why? We'll take it up on Monday.
Monday is lordship after expiry of specific period or 60 days over. And you also consider maybe already
We'll pass orders on Monday.
already lordship 58 days, 9 days. Only 1 day is lordship, can you consider it? Main case already conversion.
We cannot consider unless it is on that particular day. We can consider on merit.
Yes, lordship, but lordship, only 56 years only, lordship, not 25, 23. And now lordship, they are in this FIR lordship.
Monday, we'll take it up on Monday. We are not losing your Okay,
I listen.
Monday, list on 12th. CT received the retail, the big text. Mr. Gogoi, Mr. Koshik, we're having it on Monday.
Then hearing item 21.
That is all right, the 58, 8 days, 2 days, he has to wait, prospective period. Otherwise, there is no medical decide in the identified. Then you also have to reject it, otherwise.
We are not expressing any comment other than saying we are taking it up on Monday.
Tomorrow.
No, better today than tomorrow, unless you agree for Monday. You give me a choice.
They say only 2 days lordship.
Monday, 12.
Item 21.
Morning or
report and category of post. 2:30 actually.
today diary is not available, my lord. I had that diary was here, my lord, my lord, to make it up to date. So, one more definitely.
What is the allegation here?
304B.
But later on added here. On the economic law. The accident of fire.
When can you get it? Kamrup, Hajo. When can you get it?
20 minutes, 0.
It is submitted by Learned APP that CT along with PM reports has not been received. He therefore prays for a short date. Mr. Sharma submits that petitioner is not on pay, not on interim, therefore Mr. Hazarati is not on bail, therefore short date be granted. Accordingly, let the matter be listed again on 20.
Yes.
20 June, enabling the Learned APP to produce the CD along with the post-mortem report.
Okay.
Item 22.
Non-APR matter, scan copy was called for earlier and the taking that diary, scan copy also not received. Absolutely, that's it. Oh, yeah, for
None appears. List after a week.
Twenty-three.
PM can be part of same.
20. 20. Yes, 20%.
24, somebody mentioned. 24 mentioned was in 24.
Diary also not.
25.
Who
Mentioned.
Oh, okay. Diary not received.
Not received.
Is submitted by Learned APP that CD or has not been received. Let the matter be listed again on 20,
Along with PM.
Yes.
along with PM. PM reports be listed on 20. Both the matters. 24, 25.
26.
It is going to. Only in the first page of lordship, we already signed up. Now, lordship, the evening to lordship, they are the other in lordship, other than mother-in-law. This is a condition of parent for the condition number 1. If I lordship is scale lordship, it has to be listed. So basically, lordship is says lordship. There is some lordship after there is some. I mean, even of
CD PM with FSL.
Yesterday received.
But postmortem report is a negative.
FSL also,
Yes.
perhaps.
Where the now parents, because only one was your husband is always under. So was it, I mean, interview consider for us. That only parents.
From the statement of the witnesses subject, 164 statement. Who happens to be the eyewitness subject, she has indicated. The mother-in-law, that is,
Who is the eyewitness?
subject one, Jobeda Begum. This.
Let us wait for PM and PM report.
No.
This again. When can you get it? Boris Sol, 21st, 22nd,
22nd.
22nd,
Lordship.
enabling the learned deputy to call for the PM report
Lordship.
also. It is submitted, the CD has been received. CD is received, be retained in the next week fixed. Mr. So appears for the petitioner. As of.
Yeah.
22nd.
Lordship.
That's very eating notice where.
Yes, FSL has to
And
come.
only one was citizen signed up, as per the instruction of the.
19, let us start 19.
Lordship.
19.
27.
Twenty-seven, case study received. Council for the business seems to be.
None appears for the petitioner involved. This next week. We submitted that. His diary. Has been received by the learned deputy. The same may be retained. This next week. 14th.
Lordship.
28.
You did place it was called for.
Huh?
It was called for in this case. Earlier the case.
CD.
City doctor statement.
Earlier the informant is not another category taking the from 98 given. That case for the 35 and also the charge already start 10 minor and they did 12 6 minor. And subsequently matter to the false allegation. Another thing, check test minor, definitely it is 15 minutes. Right. And earlier one is 10,
Page 15.
50, 1 minute. Entire family member. Radula, Regina, all the family member.
CD not received.
Not received.
Who is the petitioner? Husband.
Rajula.
Who is he?
That's number one, Lordship.
Husband.
Lordship.
You wait for CD.
Some protection.
Wait for CD.
Some protection. Earlier, the informant.
Budget years.
Hmm.
At least 10 minutes.
Can we reverse it? Date for this statement?
Already checked here, started submitted, start of the time.
Get it on 14?
Lordship.
14?
Okay.
Okay.
No, 14.
14 June. List on 14 June. Call for CD.
Orders, I think 30.
Yes.
Last opinion, the register was directed to verify the record. For finding the steps by the petitioner.
The office note indicates that, office note dated 19/3/2020.
So see, it was received back as unserved.
And then thereafter, lordship, there is an order, office note, 19/3/2020.
No, 6/6/6 is the last order. Last 6/6/23 is the last office note.
6/6/20.
6/6/23.
23 order.
No, this is the office note. 19/3/2020,
Yes, okay.
office note says she has left.
Personal address, we have taken step on personal address of the informant.
You go through the office note.
Lordship, I have seen the record where my that steps registered with registered post was lying in it, is lying inside the
File.
record. Yes. The registry. They have not served the notice. And they wanted to that it is registered post lordship, was taken on 7/2/2020 lordship. That was lying inside the record. They want some personal address of the informant. But I have given the address. Which they have given, the informant has given. Yes, that's a picture.
What is the new address?
But earlier the picture of also filed an application because this under 482. It was dismissed on non-prosecution of lordship on 21.
What is the new address?
New address.
New address.
We do not know about new address because they.
No, you said you have taken, there is one envelope here. Is this what you're?
The personal address of that time, the informant has given this address.
Uh.
The FIR lordship, at the time of filing of the FIR. I do not know the new address.
Then,
Three, 4 times we have taken the step.
so you suggest what is to be done? You tell us. How do you want to serve the notice?
Because there is 3 cases were pending before the in the court of Chief Judicial Magistrate Kamrut lordship, which was filed by the petitioner again under section 138 NIA. And all the cases were filed due to non-service of the summons or warrant against the husband of the informant lordship. And all the cases were filed.
Now, what is your prayer?
My prayer is Lordship, maybe the to police of this 2 years, but it is not possible because my case also in warrant was issued, and in that case also the notice has not been served upon her.
So what is your prayer now?
Now my prayer is frame over the further proceeding. Because your lordship, earlier there was no stay in this case, lordship. And next day was fixed in this case in the additional civil court on 7/7, lordship. Still service of notice, lordship, they may be granted in this case.
No, but service of notice, you'll have to have the address first.
Lordship, earlier on, annexure 11.
Your matter is pending before the court below.
Yes, lordship.
You procure the address and take steps accordingly. What is the stage in the court below? What is the stage?
Present case, because earlier we have filed because in the year 2011, lordship, annexure 11, there is stay order of this honorable court. After dismissal of the case on for non-prosecution,
I have again filed this application under 482 notice. And on the first day on 9/1/19, this honorable court also passed order issuing notice upon the opposite party, and there is an order to that next day the court will consider my
Upon new service,
notice after service of notice.
correct.
That is the prayer. But initial order, the Lordship at page 75, election 11. Lordship. Without service of notice, this stay was granted, Lordship.
So that is what I'm asking you, what is the stage of the proceeding below today? What are your instructions?
That again be or allotted below, Lordship issued summons to the petitioner to appear on the next, on 7th of July. Yes, not appear, appear.
Probably the case is pending in the state of appearance.
But you still have to find a way to take steps, assuming we stay, then you'll have to take steps. You have filed a petition.
Well, Lordship, I have given the step, I have submitted steps several occasions since
Find out what order.
2011, Lordship.
Correct, but if you're suggesting you don't know the address and therefore you can't take the steps, how do we proceed in the matter? You have to find a. You have to-
I am the accused, whether I will find out that person, Lordship.
Or should be a case notice to the concerned proceeding.
Which police station?
This full police station. Previous address was this full, at Noyanpur.
What is the order of the court below? Is there any order passed? Nothing.
No. It is at the stage of appearance.
What is the name of the opposite side, other side, respondent?
One thing of the Hindu Devi.
Panjir.
Panjir. Allegation under section 376.
And what is your name?
Vidya Kapoor. I have given 4,60,000 by different check. To the husband of the informant. And for that, Lordship, they had given 3 checks,
For the
and
parties.
we have filed
Pursuant to the last law is passed, the office verified and has given a note that steps taken earlier has been returned with the endorsement within the court's unserved with a report that the addressee had left the house in 2011. Therefore, notice could not be issued of the respondent to. For further, it is mentioned that no further step has been received by this section. Also, then it comes into the petitioner and they submits that she has no knowledge about the current address of the opposite party. The address, the last known address known to the petitioner. In the last known address known to the petitioner, steps were taken, but the same has not been served as per. In spite of steps taken by the petitioner. Also, Learned Counsel for the petitioner submits that the next date in the matter has been fixed in July 7th.
yes, Lord.
July 7th. Accordingly, she submits that the proceedings in the court below be stayed in as much as this criminal petition. That earlier a criminal petition being criminal petition number 566 of 2011 was filed by her, filed by the present petitioner against the same respondent, wherein by order dated 28/11/2011, this court, while issuing notice, had suspended had stayed the proceedings in GR case number 1797 of 2010, pending before the Court of Additional CJM Kamru Party till the next return date. So the matter, however, came to be dismissed for non-prosecution. By the order dated 21/2/2018, passed in criminal petition 566 of 2018. Also, interim order dated 28/11/2011 has also been vacated. Also, no appeal, no further appeal has been filed against the order passed by this court dismissing the criminal petition for defaults, for non-prosecution. Instead, the present criminal petition has been filed by the petitioner again, challenging the for the setting, praying for setting aside and quashing of the proceedings pending before the Court of Additional CJM Kamrup Metro Guwahati, the GR arising out of GR case number 1797 of 2010. We submitted that the next date fixed in the matter as per our instructions is on 7/7. Also, let the notice on responding be served through the OC, District Police Station, within 2 weeks, 3 weeks from the petitioner needs to take steps, is to furnish extra copies, enabling the OC to carry out the orders of this court for service of notice on respondent number 2. Posting. We are fixing it at the end of June. By which time, let us see if any service can be done, taken up. Thereafter, your prayer for interim will be considered.
Yes.
Reason is very simple, that your petition was dismissed. You did not file any appeal.
Against there is some judgment of the Honorable Supreme Court
Say,
regarding that when the criminal petition is pending, it should be disposed of as per merit.
exactly. But then it was dismissed and you did not go in appeal.
No, we have had second second criminal division petition.
That's what I'm saying. Earlier order still remains. Dismissal for non-prosecution
Yes.
remains. Against that, no appeal has been filed.
No.
Against that, no appeal has been filed.
Against that, we have not filed any appeal. I have filed a fresh petition, criminal petition, already.
Let the matter be listed again on, we'll have it on 26th. Wait.
Yes.
Wait. For further orders. List accordingly. Steps within 2 weeks. Within 2 weeks. Steps within 2 weeks. Copy of this order be marked to the office of the London EP. For onward communication to the OC, the school police station.
Item 31,
Third, working with the decision maker. I don't think the proceeding that is pending for the current time. But here, Miller. By the earlier order, Miller, the letter is.
Service report awaited. Service report is awaited.
By the order dated 16/2022, Miller. It was observed, Miller, for consideration of the intake period of the petitioner, Miller, on receipt of the record. So the report is.
You are challenging what? The watching of the order.
Receipt as well as the Miller order taking cognizance of the office. Now, Miller, here the factors are. One of the customer of the HDFC Bank, he had deposited a check in one of the branch at Guwahati. And as it was with a CPS compliance check, it had gone to the service branch. Whereupon it was credited to the Troy Bank. And the Troy Bank, after scrutinizing the check, the amount was released to us, and then we have credited the amount to the customer's account. Thereafter, the FIR came to be filed, saying that the particular check was a duplicate check. And on the request of the Troy Bank, we have initially freezed the account. The amount was kept in hold. And thereafter, pursuant to the order of the trial court, the amount was given to the informant's account. So far as my role is concerned, at that moment, at that particular time, I was the branch manager of the service branch. And my duty was to check if there is any overlapping in the check, the dates, etc. are correct or not. And thereafter, the scan copy of the check is to be sent to the Troy Bank. This is the Troy Bank which checks the signature, etc. And thereafter, they release the amount. That much is my involvement in the particular incident. But then now, on the basis of the FIR, there is no allegation against the any of the officers of the HDFC Bank. The section 420, 460, etc. have been the registered. Charge sheet has been submitted, cognizance has been taken. The Lordship may kindly come to the FIR is at page 30. Now, presently, I have been posted out of Guwahati, I am at Calcutta. The proceeding is there. Specifically, come to this page 30 is the FIR. This will inform me that we had issued one check, so and so dated for ₹30,000 only. Sri Ratneshwar Das has PF loan, which Sri Das had deposited at EPI, Panipula branch for clearance. However, the check was dishonored by Allahabad Bank Tinsukia branch due to insufficient fund in our account. This check is not in question now. The second paragraph. On inquiry with Allahabad Bank Tinsukia branch, it is learned that the bank has honored a check bearing serial number so and so dated 24/2018 for ₹14,50,000, favoring a party Boliho Media who had deposited the check to HDFC Bank Guwahati for clearance. Surprisingly, the check was duplicate check only issued fraudulently by saying mistake by copying our signature and duplicate check leaf. Actually, the original check serial number 33294 dated 24/2018 for 87,660.46 only was issued by us to Srimati Padma Delhi, a temporary worker of a STB PF statement, which deposited to United Bank of India, Panipura branch of Center, presently being held back by Allahabad Bank Tinsukia. This is serious matter, and you are requested to investigate the matter and do the needful urgently and request for FIR. The owner of Boliho Media, Ariful Ahmed and Miss Dipsika Kashyap, along with their friend Mrinal Palita, was in our office on 23/2018, and you have investigated them personally at the manager's office. Their confession in front of you and all related documents along with the ID proof is attached here for your reference. It is the Allahabad Bank at Tinsukia branch, which has cleared the check. After verification of the check, they have released the amount. It is not in our hand, my lord, to verify the signature, whether it is genuine or duplicate, because the original records are with them, we send this, then put it and verify and then they send. Now, after this, FIR, my lord, personally, my lord, request of the Allahabad Bank, my lord, we have freeze the account, my lord, with fine.
Is the account of value,
Account of the client, my lord.
which
That
client?
is 28
That media.
media with the amount, is 28.
Yes.
Page 29. Principal implement by you covering letter issued by C/1 drawing of an instrument of part third hello, which established that elite check favorite Bollywood media was received by you from prior the instrument in good faith to prove the document proof which established that elite instrument was again the genuine personal transaction, and as such the amount herein was legitimately due to you from the drawer, and you were actually for this person to title over the letter from the drawer of the instrument confirming issuance and delivery of the elite instrument to you, which subjects the yours qualified to be considered. Whether the confession done by you before the claim is come to us in absence of conveniencing explanation of document proof as requested above.
This,
We request-
this FIR, this, the matter relating to you proceeded on whose FIR?
It was the owner of the check, MK Jokai, at page 30.
And then why the charge sheet it is shown? Who is the manager in the charge sheet, page 49?
Page 49. But all the names have been given, including me.
No, complainant, who is the complainant here?
It is
He is the manager,
Bora.
is the manager.
Just you know, particular piece statement. A unit of the MK Jokai.
You are shown as an accused.
No. And in fact, the police has investigated the case. They had asked us regarding the CCTV, etc. All these things have been given. The amount is also given back to them pursuant to the order of the court. That is 45 the order. Last paragraph, since the amount foreclosed from the bank account of the municipal company is correct for its settlement of security dues of work or is directed to take on notice to recover the aforesaid sum of rupees 14,50,000 only from HDFC Bank Guwahati and hand over the aforesaid amount in favor of informant upon activation of ₹100 to the transaction.
Has it been recovered?
This has been given to them because it was immediately it was free.
I heard, yes, madam.
Under notice was issued with the respondent number 2 notice, but the notice has been served upon the notice.
Who is not complete?
That is what we are saying.
I have a particular intent where because the official like that I have done is a very limited role. Apparently, that I have nothing to do with the
Third level councils for the parties, the office note reflects, office note dated so and so reflects that service report from the district magistrate in Sukia is awaiting. In respect of respondent number 2. Respondent number 1 is represented by an additional PP. Notice in this matter was issued. Scan copy of the LCR was called for. LCR in connection with PRC number 499 of 2018
And still received the
pending in the court of CJM in Sukia connected to arising out of GR case number 540 of 2018 was called for by order dated 1/5/2023 and copies of which have been received. So, it was further directed that prayer for interim Yes, subsequently by order dated 16/12/2022, notice was issued and was directed that prayer for interim will be considered upon receipt of the LCR. Third learned councils. It is submitted that the petitioner was, what was he? Branch manager,
Branch manager of the service branch of the HDFC Bank.
service branch of the HDFC Bank at
Guwahati.
Guwahati. In connection to an FIR,
Presently, Melody is at Calcutta.
and presently is posted at Calcutta. Pursuant to an FIR dated 20 March 2018, lodged by the informant, who's the the Panitola Tea Estate, which is a tea estate under the MK Jokai Agri Plantations Private Limited Group of Companies. In the said FIR, it was alleged that a check amounting to rupees 14,50,000 in favor of a party named Ballyhoo Media was deposited in HDFC Bank Guwahati for clearance. Also, the check was transmitted to Allahabad Bank Tinsukia branch, in which the account of the informant was maintained. Also, is alleged that the said check is a duplicate check fraudulently created by the miscreants, copying their signatures and duplicate check leaf. Also, the amount of 14,50,000 was cleared from the account maintained by the so and so tea estate informant and transmitted to the account of the HDFC Bank Guwahati branch in favor of Ballyhoo Media. Also, the said FIR was received and registered as Tinsukia PS case number 330 of 2018 under section so and so. Pursuant to the investigation, when the matter was inquired into by the Ayub, the account of the said Ballyhoo Media was freezed by the HDFC Bank. Also, learned counsel for the petitioner submits that the said amount was returned back to the informant in the meantime. It is submitted that the petitioner was a branch manager at that point in time, and he had no role to play in the fraudulent activities alleged in the FIR, stated to have been committed by the persons named in the FIR. Also, it is submitted that he, being a branch manager, only performed the necessary official endorsements required and sent the check for clearance. There was no occasion to doubt the duplicity of the said check at the time when the check was sent for clearance. As such, he is no way connected to the offences alleged. So, however, the Ayub, pursuant to the investigation, has submitted the charge sheet, being charge sheet number 129, dated 20/03/2018, and the Court of CJM Tinsukia by order dated 24/07/2019 had taken cognizance and summons have been issued. Also, the counsel for the petitioner submits that a plain reading of the FIR, no case is made out against the petitioner, nor is he referred to in the same FI. Full stop. There is no allegation made by the informant against the petitioner that he had committed any fraudulent activity. Full stop. The IO, without proper inquiry, has rejected the petitioner as one of the accused persons in the charge sheet that has been filed. Therefore, he has filed the criminal petition, trying for quashing the FIR, the charge sheet, as well as the order dated so and so, whereby cognizance was taken by the court of so and so. Learned counsel for the petitioner submits that since the matter has already proceeded and presently is in Calcutta, and in view of the order of this court reflecting that the interim prayer of the petitioner will be considered upon receipt of the case diary, this court considered it appropriate to direct that further proceedings in the so and so case. What is the case number? BRC?
Case number 499 of 2000.
499 of 2019 arising out of GR number 540 of 2018, pending before the court of CBI and Tinsukia, shall remain stayed insofar as the petitioner is concerned until the next returnable date. Full stop. List again on 27 June.
Right.
Yes, do we continue or? Yes. Partner matters. Is there any partner matter?
Yes, sir.
Item number
34.
34.
Item number 10 of.
Item number 10. Item number 10 is a writ petition.
On detail.
So item number 37.
It's not partner. Is it partner?
Third, but it has been heard by your lordship.
Item 35.
35 is not partner.
It is hard for you.
Hmm.
My part is hard. Yeah. Item 38 also. Partner.
Right, okay, just make it any date or begin.
Monday. On Monday. 12th. Item 10. 12th.
Item 30.
Fourth, lordship,
34 also on Monday.
can it be on,
Monday?
Tuesday?
No, sorry, not 34. That writ petition.
Not about 30 maybe after 28.
37 on also on Monday.
Monday, not not the current number, Tuesday. Tuesday, hearing,
Monday.
not a Monday.
Yes, then
Similar here, my lord, item number 43, my. Item number 43.
yes.
My lord, then
We can make it on.
Item 38.
Just 1 minute, just a minute. Yeah,
43, my lord.
43, 43, supplement.
Any convenient date, my lord, shortly.
The short date is the problem.
My lord, my lord. Tuesday, my lord.
13th, right.
And 30, lordship, Tuesday.
All right. 34 also on Tuesday.
Item 35.
Okay.
35 also on Tuesday, yes. Whatever,
Item number 38.
38.
Commencing any day after 23rd of June.
that would be difficult. Then it has to go to July. Then it has to go to July.
Then it will be earlier.
Huh?
Then it will be fixed earlier.
Earlier.
On 16 or not?
All right, 16 we try. 16. 16 June.
15. I think about 45.
Yes.
It is like 13.
Hmm?
I don't know, but it will be take some 13.
Why?
Maintenance payment related to maintenance of the site. Yeah, then it will be.
Right, urgent, but why is it for hearing?
This is final hearing. This is for enhancement of maintenance fine for the site.
16th. 16th.
Always.
Yes, Dr. Saraf? Any date, it has to come on some other date. I mean, fixing
Vacation.
after vacation. Come after vacation, I think, convenient date. We'll not fix a date now because it's too early to fix a date. So let it come after vacations.